Good morning. I'm Kelvin Lim. I'm the Vice Chair for Research, and I'd like to welcome you to today's grand rounds for psychiatry. And I'd like to introduce our speaker, Francis Chen. Francis Chen is an interesting fellow. He is on the joined the faculty in the law school in July of 2012. And he has an interesting background. He has a JD from Harvard and also a PhD in government and study policy, also from Harvard. And he has a specific interest in terms of, as you see from his logo here, about neurolab, and the title for his talk about law and neuroscience. So you may wonder, how deep does this interest go, right? And it turns out Francis has joined the MR users group here at CMRR. He's taken an EEG analysis class by Steve Luck that was presented here, and he was just telling me that he just spent 40 hours at a course on transcranial direct current stimulation being held by Bixen's group in New York City. So he's into this. So you're going to talk a little bit about neuroscience, also its relation to psychiatry. So let's welcome Francis.
All right. Well, thanks. Thank you very much. Move this up. Thanks, Kelvin, for setting this up. I really appreciate it. I'm here, so I have to just give this disclosure. I have no financial relationships to disclose. I wish I had some financial relationships to disclose. I don't, and nothing else. I figured I'd start, since you know a little bit about me, with a picture of my brain. And the reason I start with that, this was taken in 2009 in the summer at UC Santa Barbara as part of Brain Camp. I was hanging out with other graduate students in neuroscience. And the reason I start with this is that it really begs the basic question of neuroscience and law, which is why. Why should someone on the law side, on the policy side, be concerned and be interested and spend their time in neuroscience? And there are a lot of ways to answer this question. But most of the answers, I think any legitimate answer, boils down to some version of, to the extent that law, broadly defined, law and policy, cares about the regulation of human behavior, which I think it's fair to say we do to a large extent, then if neuroscience can give us some meaningful value added to understanding human behavior, why it is we think the way we do, or act the way we do, or perhaps more precisely why we sometimes, or why others sometimes don't do or act the way we wish they would. If neuroscience gives us some added purchase, then maybe law and policy can do its job better. That's the hook. And frankly, that's the hook of decades-long promise, though maybe not often realized, of biological psychiatry, new work by my colleague Reid Montague and others in computational psychiatry. Can this new knowledge improve the work that we wake up and do every day? And mine is a little bit than yours, but that basic premise, again, that basic hook is many saying, at least in some instances, yes, we might have something that can help you. So that's the sort of hook of our field, and as I talk a little bit about it today, I'm going to suggest that it's sometimes premature and inappropriate, other times very promising, and trying to figure out that wheat from chaff is a lot of what I do. I just sort of described this, why neurolaw. Just a few other words of introduction. We try and answer that question in my lab. It's a small little outfit over in the law school. Our motto, every story is a brain story, and I do think that's true, even if every story is, at present, a very poorly understood brain story. Sometimes even reframing this may have some implications. We do work online with subjects. I'm out at the State Fair recruiting subjects. President Kaler was even a subject in our study this summer. If you want to learn more about our lab, you can see it there. I'll only talk a little bit about our work and more broadly about the field. The other thing I want to introduce is I serve as Executive Director of Education and Outreach for a MacArthur Foundation-funded group called the MacArthur Foundation Research Network on Law and Neuroscience. And I mention it because www.lawneuro.org is really sort of the center space for information in this area, and if you want to know more, you can go there. In that role, what I do is I'm in front of judges regularly, attorneys, others, trying to improve the dialogue between science and law, and again, that's not new. Those of you who work in forensic work have been trying to do that, and often very successfully for many years. We're trying to continue that tradition by introducing neuroscience. So 3 things I want to do today. First, talk about the past, and there really is a good, bad, and in some ways, very frankly, ugly. Talk mostly about the present, kind of where we are today, and then to think with you about the future. I think if we consider today a courtship between neuroscience and law, kind of where does it go? Marriage, divorce, and what role for psychiatry along the way? Let's start with the past. I think, and I'm sort of writing a longer piece about the overlooked history of neurolaw, I think too frequently, and I fall in this trap as well, we think about neuroscience as new, and therefore neurolaw is new, and neuroeconomics and neuromarketing and all this stuff as new. And in many ways it is. CMRR across the way didn't exist 40 years ago. MR imaging, and as we know it today, is relatively new. But in other ways, the dialogue between brain science and law and policy and brain science in society has been ongoing for centuries. And I'm just going to give you a couple of snippets of that, sort of one good example and one maybe not so good example. So I think one really good example is epilepsy. When the country was founded, amongst George Washington's children was one daughter named Patsy who suffered from what we would today consider epilepsy. Here's how they treated it: with a ring. They gave her a special ring, and the reason they gave her a special ring is that it was designed to ward off those evil spirits, because that was our understanding of epilepsy at the time. There were a lot of legal and policy implications of this conception of epilepsy. Two of them of import. There were pretty draconian laws, even here in the United States, up and through a decent part of the 20th century. And socially, epileptics in many parts of the states and elsewhere were seen as outcasts, almost sort of as lepers. We've made tremendous strides, obviously, including here at the U, in understanding epilepsy, and so it is no question that if you go to Epilepsy Foundation, it is clear the human brain, not evil spirits, is the source of all human epilepsy. And it's not just that we've improved understanding and treatment. The social stigma around epilepsy has changed, and we've experienced this a lot here at the U with Coach Kill. I think Coach Kill's experience is really a good example, where on one hand, we still don't have the medical science necessary to allow him to still coach. On the other hand, we have enough knowledge that when he has had, and I've been at one of these games a couple years ago when he had a seizure, everyone in the stands was concerned about him. I'm pretty sure that not a single person in the stands thought, my goodness, what evil thing did Coach Kill do? He brought this upon himself. He chose to have that seizure. He's a bad person. Yet we do that, as you well know, with many other types of mental disorders, mental diseases. And so query, in 200 years, if we look back to George Washington, if we look forward 200, 300 years, in what other types of social changes might we see? So I think epilepsy is a good example where laws have changed, policy has changed, society has changed as our medical understanding and treatment has changed. But it's not always the case that things get better. And I'll use the example of understanding violence. So historically, this has been an interesting question. Most recently, there's a colleague at UPenn named Adrian Rain who wrote a book, The Anatomy of Violence, The Biological Roots of Crime. I won't talk about the book, though it's interesting. What he tries to do, and he does a lot of PET imaging, is understand what makes the brains of murderers different from the brains of everyone else. But he's not the first person to ask and try to answer that question. We go back 40 years ago, there's a book, Violence in the Brain, by Vernon Mark and Frank Irvin, so a psychiatrist and a neurosurgeon, leading psychiatrists and neurosurgeons out of Harvard and Mass General, doing this work. Quick show of hands, has anyone in the room ever heard of this book and their work? Looks like 1, 2 hands. I asked the same question, Chimoy was there. He was. Fantastic. So we've got a string, and there are some connections, but the majority of even forensic psychiatrists thinking about violent brains have never heard of this book and their work. I'm going to tell you just a bit about it, but it's interesting. Historically, and indeed Adrian, who's a friend of mine, I wrote a review and I said, he didn't even cite this book. And he said, well, I didn't cite it because I never read it. It's interesting that, again, this work is not cited. It was popular at the time, so late 60s and into the 70s. So here it was. Scientists studying over-aggressive behavior are now implicating brain damage from hitherto hidden sources, new clues to the causes of violence, and their work was involving psychosurgery. So one of their famous patients is patient Julia. Before deep brain stimulation, they were using sort of remote-controlled stimulation. Apart from the work of Delgado at Yale, they were targeting, in part, the amygdala. And when they targeted and electrified it, there she goes. Julia, after DBS, rage behavior attacking Wallace suddenly and unexpectedly. Now, today we cannot do some of the work like this for understandable reasons, but their idea Their idea, and I'm going to keep this image up, just it might be a little distressing, but I think it's important, is that what motivated them is, that very same premise I gave you at the beginning. If we could better understand why individuals sometimes become violent, could law better solve its intractable problem of dealing with this violence? And their answer was yes, and their proposed solution was a form of psychosurgery. Now, it didn't have the benefits that it promised. That also with the rise around the same time of pharmaceutical interventions, which are cheaper and easier, sort of left this away. But an important historical moment that we've tried this before hasn't always worked. But we can go back even further. 1933, you will know Egas Moniz, who wins the Nobel Prize for the prefrontal lobotomy. And this not only captured the attention of others in the medical field, but those in law as well. I'm going to give you a quote from the Yale Law Journal. The Yale Law Journal is the equivalent of Science or Nature, the biggest, most impressive law review around. And here's what they had to say in 1948, reflecting on the potential for this science, the lobotomy, to improve the work in law. Quote, "Psychosurgery has startling implications for rehabilitation, and it is proving successful in an increasing number of cases. Perfection of so relatively simple and inexpensive a rehabilitative technique as the prefrontal lobotomy promises to be a major contribution to the cure of criminals." I don't have to tell you that the history of the lobotomy is a difficult one, a tragic one. But again, that promise was there. Here's law saying, science, can you help us figure out this problem, the violence? Science says, yes, we can. Law says, well, let's make sure that it's vetted. Let's make sure that it's good science. Science says, how about a Nobel Prize? Is that good enough? And then they move forward. And this is going to be one of the core concerns that we've now moved through what's happening currently, which is when is a particular technology, particular approach, a particular science ready for a particular use? And again, you have that in your own clinical work. We have that in law. Our questions are related, though a little bit different, but I think the core challenge is still there. So let me talk about the present and walk through, first just recognizing that brain science is everywhere. And this has a lot of implications because one of the reasons we're seeing more brain science in law, and that maybe your patients are talking more about brain science, is they're just seeing it more places. Both in Europe and the Human Brain Project, and here our Brain Initiative, of which many researchers here at the U are involved, there's new energy and investment in the brain. It's showing up in policy all the time. Within the last couple of years, just here in Minnesota, that's the federal level. Here it is, state level. Mini Minds, which is a advocacy group, an interest group, and wanted more investment in education from 0 through 5. If you pulled up their slide deck, I pulled this right from their slide deck. One of their slides, amongst the other economic and all their other arguments, is 90% of brain development occurs by age 5. Now, that sort of claim is good for a slide deck. The precision of it is one thing, but if this helps them promote their goals and get the funding they want, is it a good use? We're going to see that question show up. Here's another example.
This is a baby's brain. This is a baby's brain on books. 90% of a baby's brain growth happens between the ages of birth and age 5. You can help your baby's brain get ready for learning by reading to your baby every day. Sharing books helps you make a connection with your child that will last a lifetime. Go to makewayforbooks.org. Make sure your baby's brain is ready to learn.
So this PSA aired in Pittsburgh, and of course, that's not what a baby's brain on books looks like. We don't know what a baby's brain on books looks like, but what if, imagine with me for a moment, some parents saw that, and for whatever reason, although their doctor and you had been telling them, read your child, they saw that, or a number of parents saw that, okay, now I'm going to do it. And over time, those kids did a little better off, and then they did a little better in life. All because of this ad. Would that be a good use of the brain science or a misuse of the brain science? By what criteria will you assess the neuroscientific claims? I'll give you just one more video.
I've got emails, phone calls, news to stay up on. It's like my brain's under siege out there. I just needed an edge. And Lumosity has all these games based on neuroscience. And my brain can really tell the difference. I'm still under siege. I'm just better armed.
Any brain can get better, and Lumosity.com can help. It's like a personal trainer for your brain, improving your performance with the science of neuroplasticity, but in a way that just feels like games. Start training with Lumosity.com right now and discover what your brain can do.
And there's something about when you make these ads, you have to have things shooting out of the head. Lumosity is making a lot of money. This ad actually ran during the Super Bowl, or a version like it, and they've got ads targeted at the older population. And there's an ongoing scientific debate about whether or not these cognitive games just make you a little bit better at that game, or whether they somehow give you broad improvements to working memory or the cognitive function of the type that are advertised there. And again, how do we evaluate those claims? Is that a useful, a neutral, a bad use of neuroscience? We're seeing it at all ages of the spectrum. So at the older ages, I love this headline, neurobic exercises, keep your brain alive, available in 22 languages. So somebody's buying this stuff, and they're also buying these sorts of things. Neuro-Optimizer, Neuromax, NeuroClear, Neuro1, Mental Performance Formula, Fuel for Thought. No, I have no idea what any of these do. Part of the big reason is that they go through a different regulatory track than some other so-called enhancers. So this stuff is out there. It's even on the bananas you eat. This is a real type of claim, brain fuel. And the last slide I will give you, even though we could talk the rest of the day and really the week of the month about brain claims, this next one will prove, I think, scientifically that everyone wants to get involved in brain science. Quote, Goldie Hawn plunges into brain science in her 10 mindful minutes, right? So this is, again, sort of the promise and the peril. On one hand, there's a promise that, boy, folks are starting to recognize the special nature of the brain and in somehow its relation to mental function. On the other hand, they're picking up 10 mindful minutes by Goldie Hawn and coming to your office and saying, I think I know how to set my life straight, right? And we're seeing this in the courtroom. So it's everywhere, including the courts. There's some evidence now gathered. This is one data set. There are a couple others tracking the number of cases that involve some sort of neuroscientific evidence. And the rough consensus amongst the field is that there are a growing number of these cases. But still, the overall number is, the y-axis here only goes up to 350. And although this doesn't count them all, even if you did count them all and multiply that by a factor of 3 or more, 10,000, that's a really, really small slice of all cases. My own view is that we may be headed, at least in part, to neuroscience and neuroimaging in the courtroom as instant replay. It's the case that instant replay has fundamentally changed the nature of some sports, despite the fact that the vast majority of plays don't involve instant replay. When do you invoke instant replay? Either when it's really, the stakes are really high, like they just scored a touchdown and you want to be sure you're right, or when it's unclear, like the foot's just on the line and you don't trust your own judgment, or someone else doesn't trust your own judgment, and you think those extra camera angles may help, right? And not unlike when you might ask for a second opinion. Again, the crucial question is, do you get anything more conclusive? Do you have the right camera angle or the right brain data that will be useful? And I think that remains an open question. But clearly we have this trend. I don't see any reason why this trend would slow down. We're seeing it in legal scholarship. This graph going up, we've seen many, many more publications, and this is kind of tracking interest in the field. It's sometime after 2000, really around 2005, and really just in the last 5, 6, 7 years that there's been this kind of explosion. And again, I think that's somewhat in keeping with what at least one psychiatrist called the sort of third wave of biological psychiatry, the introduction of computational psychiatry. Things are starting to happen in tandem here. It's also showing up in law classrooms. This is the book that I've co-authored, Law and Neuroscience. It's being taught in law schools, including ours and others around the country. Not a lot, but this is something that didn't exist a decade ago. So it's showing up there. I'll just mention that because one of the things I study is showing up in legislatures too, kind of same data pattern. The things that our state legislature and others are concerned about, Alzheimer's, brain injury, early childhood, healthcare, mental health, sports concussions, and others. Again, brain science showing up in a lot of places. But what exactly does it look like? I mean, there are all the numbers. Let me give you some case examples. So in the criminal law, and I'm going to emphasize that it's not all about the criminal law, but on the criminal side, there are a lot of versions of my brain made me do it, or my brain tumor made me do it, or the brain accident I had as a young child made me do this thing. As the philosophers has asked, did my neurons make me do it? In the philosophy of mind world, in the scholarly world, lots of ink has been spilled on questions of free will and determinism. It's not my area of work, and frankly, as a matter of practical legal implications, it's had no implication. So there's no court around that it's buying the view that we are living in a hard determinist world. That hasn't happened, but there are some sort of more compatibilist views floating around that some courts are at least open to considering, which is, well, maybe there was some more limited self-control than we once let on. So here are some examples. These could give you many, but just from this past summer, lawyer, Rensselaer man who bit off mom's finger was brain damaged as a child. Here's another one. This is more serious and ongoing. Lawyer cites teacher's brain condition in student sex assault. This is a New Jersey teacher case that's ongoing. She is claiming that her frontal lobe dysfunction, and there was some medical history there, prevented her, did not allow her to then stop from engaging in this sexual behavior with the teenage boys in her classroom. Now, the nature, the logic of these claims is not at all new to law. We've seen this for many years, my rotten social background, this, and this. That's the reason that I did these things. And so, Your Honor, either I'm not guilty by reason of insanity or for some other excusing reason, or more likely, yes, I'm guilty, but when it comes to sentencing, you ought to send me in a different path than you would if I had that healthy, normal, functioning brain. What's different now is that in the evidence that they're presenting, it's not just calling their psychiatrist to the stand, they're also introducing, in many of these cases, brain data, a variety of brain data, QEEG, EEG data, fMRI, MRI, PET scans, SPECT scans, and that is something that the legal system is trying to confront. Here's one person who does it. I'll just give him, he's going to talk to you in his own words with the video, because if you know about the criminal justice system, you know that most things don't happen in front of 12 people in a jury. The vast majority of cases, 80, 90, 95% or more, resolve themselves through a plea bargaining process. Attorney Stephen Cobb, who is in Florida, knows this. He's the first in the nation to really get on the neurolaw bandwagon in some problematic ways, in my view, but maybe not for his clients. Here's what he does.
Most cases settle. That's the truth. So how do we handle that? Well, one of the things that is most innovative about our law firm is we're the first law firm in the United States, if not the world, to use neuroimaging for damage control in criminal cases. What do I mean? Well, take a look at the pictures on the screen right now. Those are pictures of a healthy, normal range brain image. And when you see the next set of images, this set of images right here, you can see these are completely different. A lot of different things can harm the brain, and we all know that human behavior is a direct result about everything we think and feel and how well the brain is working. When you or a family member finds yourself in legal trouble, not once, not twice, but over and over again, or in a relationship that's having significant problems leading to an arrest, or in whatever aspect of life, you have things that just aren't going right, and then boom, you or someone you love gets arrested. We know that every single time when the brain is imaged, there are going to be health problems.
Okay, I mean, what a claim. Every single time there are going to be health problems, and they're going to look like that. I mean, I can't even start to tell you the number of problematic things there. And those, by the way, come from a sort of satellite of the Amen Clinic. So you can, it's a problematic there. But here's what he would argue, and here's what his clients might argue. What are the results of his approach? Well, the prosecutor's got this stack of cases, and they're dealing with this lawyer, this lawyer. Here's Attorney Cobb. And he's got all the other stuff that's usually in that file, and then he's got these brain images, certified by a psychiatrist. And the prosecutor, well, I don't know, looks legit. All right, I'm going to give you a reduced sentence. And that starts to happen every time with Cobb's clients. And by the way, he seems to have some success. If he goes back to that client and says, well, you know, client, you hired me and paid me good money to represent you, and I could have introduced some evidence that would have given you a better sentence, but I did my own PubMed search, and I decided not to do that. Not only would he be fired, he might well face an ineffective assistance of counsel claim. And if you ask those clients, do you think it was a good use of the science, they would say better off. And if you ask their families, they would say yes. And there are some advocates who would say, look, the system is so problematic anyway, that yeah, I understand that you're telling me that we can't really draw the inferences, especially the causal inferences you're saying. I understand that, but I don't care. I'm going to use it anyway, in the same way that I might use that image of babies' brains because I want to encourage parents to read more. In the same way, I might use that slide deck because I want to invest more money in 0 through 5. These are the challenges that we face. Is it a good use or a misuse of that science? Let me give you some more cases where we're seeing this. This is a man named Herbert Weinstein. This is a famous case. It's from the early 1990s in New York. Famous case because it was the first case in New York, one of the first in the nations to consider the admissibility. This was the PET image, and he had an arachnoid cyst in the frontal lobe, and this image was clear. It was clear, and we clearly had the arachnoid cyst. He also did this. He took his wife, strangled her from there, and then to make it look like a suicide, threw her out of the window of their 13th-story New York apartment building. And there was no question that he did it. He was going to plead not guilty by reason of insanity, and he wanted to introduce this image. And the question that the judge had to decide was, will I allow the jury to see this image? The concern of some was that they would see this big gaping hole in his brain, and although there was no, and continues today, to be no body of evidence that would causally link this abnormality to the particular behavior, the particular criminal behavior, a jury might be overly persuaded. Now, in this particular case, the judge did admit it, and he admitted it on this grounds, and this implicates the psychiatry community. He said, well, I'm going to admit it because I see that it's reasonable for the evaluating clinician to rely upon this neuroimaging. It turned out that this case settled for some other reasons, but it's that question, that admissibility question, that's still with us in a number of those cases, surely in some of the cases that I just gave you and will have more, and that returns in part to a question of what do you do in your own work, to what extent now or over the next 10, 15 or more years, whether it's PET or SPECT or some other type of neuroscientific evidence, will it help? And of course, DSM-5 gives us the answer right now, no, for diagnosis, but maybe that changes. And should the law move forward more quickly? Here's another example where evidence was admitted. This is Grady Nelson. You're seeing a picture of him in the courtroom. Mr. Nelson did very horrible things. He stabbed his wife over 70 times in Florida and killed her. He attempted to kill and almost killed his 2 stepchildren and did sexually assault them, and a litany of other really bad things. And at the guilt phase, there was no question that he was guilty. The only question was then going to be at the sentencing phase, because Florida is a death penalty state. Does Mr. Nelson get life without the possibility of parole, or does he get the death penalty? His attorney, an attorney named Kerry Lenneman, introduced at that time QEEG evidence. A guy named Robert Thatcher was there to supply it. I'm on record in our book as saying very critical of the admissibility and of the science here, but he argued, in Terry Lenneman's words, the attorney to the jury, my client has quote, a broken brain. And he then, had a day's worth of testimony to try and suggest this, connected it with fetal alcohol syndrome and a number of other things. This case was notable because Mr. Nelson was spared the death penalty. And the reason he was spared the death penalty, and I've got the exact quote here, was that jurors were persuaded by the brain images. Sometimes in cases, the jurors will talk to the media afterwards. In this case, they did. And if we take them at their word, and I think it's fair we can, this raises some real questions about the use of this data. So, quote, juror Dolores Cannon, a hospital secretary, quote, when the brain evidence came in, the facts about the QEEG, some of us changed our mind. Juror John Howard, an airport fleet services worker, quote, the evidence turned my decision all the way around. The technology really swayed me. After seeing the brain scans, I was convinced this guy had some sort of a brain problem. Now, not everyone bought it. Juror Leon Benbow, retired mailman, quote, all that scientific testimony, that was a waste of taxpayer money. That's phony. There's nothing wrong with that guy's brain. I happen to side with Mr. Leon Benbow, but you can see, again, the challenging question this raises, because this man, Mr. Nelson, is now going to have a life and not death on account of neuroimaging. Was that a misuse or an appropriate use of the science, and should it have been admitted? Regardless of how you come out on that decision, I think you'll agree with me that given these types of successes, we are going to see more and more of this in the court, and we have to deal with that. One more example, because it raises a challenging inferential issue. This is Christopher Simmons. There have been a series of U.S. Supreme Court cases, U.S. v. Roper, Graham, and Miller, in which the Supreme Court, under the Eighth Amendment, has had to decide what is cruel and unusual when it comes to criminally punishing juveniles. Can you kill them? Can you have them with life without parole for non-homicide crimes? The answer to both of those is no. And now the answer under Miller is you cannot have automatic life without parole sentences even for homicide crimes. There has to be a quote-unquote Miller hearing. But this is the first case in the sequence. And I bring it up, and noticeably, there is no individual brain scan here because the argument at the Supreme Court was based on group average differences. The AMA, the APA, a host of, I think, over 24 organizations filed amici briefs in this case, arguing that based on what we know, both on the psychological side and the neuroscience side, the adolescent brain is more immature, less able to control impulses, and therefore less culpable. Now, there are a lot of challenges sort of with that argument, but I just want to raise two that the justices raised in this case. The first one, and a big one, and it's the same thing you face in clinical practice, is moving from group average differences That is the claim that if we scan 17-year-olds or if we just have them do some sort of impulse control test, on average 17-year-olds look different than 37-year-olds. Moving from that data to the question of, does this particular 17-year-old have the requisite culpability? Right? Same issue if you think, right, well, you fit into this group patient, but will this particular treatment work for you? Let me just read you what Mr. Simmons did. You can decide for yourself that facts here are pretty wild. At age of 17, when he was, this is reading right from the case, when he was still a junior in high school, Christopher Simmons committed murder. Before its commission, he wanted to discuss the murder with someone in chilling, callous terms. He talked about his plan, discussing it with two friends. He proposed to commit burglary and murder by breaking and entering, and assured his friends they could, quote, get away with it because they were minors. They met about 2 a.m. They broke into this woman, Mrs. Crook's home. There she is, Shirley Crook. They entered her house. She called out, who's there? In response, they went into her bedroom. They used duct tape to cover her eyes, mouth, and bind her hands. Put Miss Crook in her minivan, drove to a state park, reinforced the bindings, covered her head with a towel, walked her to the railroad trestle spanning the Merrimack River. There they tied her hands and feet together with electrical wire, wrapped her whole face in duct tape, and threw her from the bridge, drowning her in the waters below. So here's a question. To what extent does an MRI study using a go, no-go test paradigm, right? Don't press the button when you see this, press it there. What, if anything, does that have to tell us about this type of behavior? And the answer may be something, the answer may be nothing, but those are the types of connection that were sort of inferentially being tried to draw on in this case. There's one other issue with this case that was raised in dissent, which is that about a decade earlier, a case actually arriving out of Minnesota, the similar sorts of groups had suggested an amici brief to say, actually, these adolescents in this earlier case do have some requisite capacity. That was a case that had to do with whether or not adolescent girls had the capacity to make decisions about their pregnancy on their own, or whether they needed to seek parental notification. It raised to a question of whether the APA flip-flop in that case, and their response is yes and no. But again, trying to get at these really difficult cognitive processes, such as culpability, that the law cares about, and connecting to neuroscience becomes extremely difficult, but it's happening in cases right now. In the remaining time, let me just give you some other sets of cases so you just get some sense. It's not just about the criminal law, and in fact, the majority of our book is not about the criminal law. It's about other things. What are some of them? Brain-based lie detection, which has shown up in courts. I'll just mention that Steve Lakin wanted to testify in an open court, quote, based on his MRI data, that this individual's brain indicates he is telling the truth in regards to not cheating or defrauding the government. He's out of business, but there is a company called No Lie MRI. Appropriately, this evidence has been kept out of court so far, but we'll see. Here are the cases that my 1Ls will take, and it's showing up in all of them. So constitutional law. Do violent video games affect kids' violent behavior, and therefore should states be able to regulate some of the sale? Well, the Supreme Court says under the First Amendment we can't regulate those direct sales, but in dissent, Justice Breyer quoted cutting-edge neuroscience. Again, I don't know if that has any import, but it's showing up in cases. Lawyering skills, we see this. How can neuroscience help us understand conflict resolution? Perhaps not much right now. We're seeing it in capacity cases. This you might be seeing right as we get to the older adult state. There are a lot of courts now asking the question, how can I tell when an individual in my court is just getting older and like grandma and grandpa losing a step or two, or do they have some sort of clinically assessed dementia, and to what role, for instance, in the Donald Sterling case, might brain images be able to play? We're seeing it a lot in tort cases, which are more traditional. So here's some milk that says DHH, omega-3 supports brain health, but does it really support brain health? Lawyers want to know, so they sued. Horizon Organics sued over claims that milk is good for your brain health. Mentioned TDCS. We're seeing this actually right now in the marketing of direct-to-consumer electrical stimulation devices. What can be said and not said? We're, of course, seeing it in ongoing discussions about concussions in the NHL. We're seeing it in the world of pain. There is a world that I'm working on the neuroimaging of pain and its implications for law. Law deals with pain all over the place, from disability claims, Social Security claims, tort claims. I'll just mention to you this case, which is raising questions about the conceptualization of mental injuries. So this is a case where a bus driver made a illegal and clearly negligent swerve in front of this train, right? Here come the crossing gates. I don't know why, but the bus driver went around them, school bus driver. This is not the actual picture, but this is probably what it looked like. And our train conductor, that's the person of interest for the legal purposes, hits the bus. You can imagine how traumatic that would be. Thankfully, there are no kids on the bus, but the driver of the bus is injured, and Charles Allen runs out of the train, he's a train conductor, and sees all this, and eventually develops PTSD. Now, it's an important and sort of useful legal case because, remember, he's the conductor of the train. So he has nary a scratch, but he also clearly has the PTSD. The statute in Michigan would only allow him to go forward with his claim if his injury was, quote, bodily injury. That's the way a lot of these statutes. So is PTSD alone a bodily injury? Well, at the district court, and they brought some PET imaging, his side argued, yes, look, how else can we understand PTSD except as physically instantiated in the brain? Exactly what those circuits are, we don't know, but clearly it's in the brain. The brain is physical. District court said, no way. Imagine if we went down that road. Then everything mental would be physical. That, by the way, was exactly their point. The appellate court, however, said, we see the logic. And they allowed him to go forward. It went up to the Michigan Supreme Court, and it's settled. So I don't know what would have happened, but we're seeing this show up. We're seeing it even here in Minnesota. Many years ago, not many, but in 2010, sort of the Red Lake shootings. I wasn't here at the time. Some teachers were, quote, physically injured, hit by gunshots. Others witnessed this, developed PTSD, and wanted to file workman's compensation claims. And the states here in Minnesota had to decide whether those claims would be considered bodily injury. Again, these teachers are over here, so they're not, quote, physically injured, but they saw it or not, right? Ongoing reconceptualization. Let me just mention here, because I want to spend 5 minutes at least talking about the future, and I'll mention some of the work we're doing, which I think implicates in many ways psychiatry. So where does this go? Well, I think this is my view. I've mentioned before sort of as an image, I think it's kind of a useful image to think that neurolaw right now is ascending, right? It's kind of like lots of stuff is ascending, but it's not at all clear to me that this is going to continue. And as someone who doesn't even have tenure and has bet my entire career on this, this is of great concern to me. It could flatline. I could have given you such a horrible talk today that you will walk out and that everyone in our field will do nothing. Unlikely, even though I might not have inspired you, but at least unlikely. But at least, it's probably more likely there's this little trickle. And there are lots of examples of this in law. Sort of law gets fascinated by this technology and that technology, and it goes up and then it just kind of moves on for a little bit. I think there actually is a possibility of really having some transformational change here. And I would say the same things about a number of fields, psychology and psychiatry. And I would call this neurolaw 2.0. And to get there, I think there's going to have to be some, obviously, set of scientific advances that I do think are coming, but are not here yet. What is DSM-6? What is DSM-7 going to be looking at? And I'll give you just a couple of examples of kind of how we're approaching this on my side, so you can get some sense. So there are sort of three things that are really easy, right? More research, more education, more dialogue. This is happening. I mentioned we bring these judges in for dialogue. We put federal judges in your seats, and we talk to them about axons and dendrites, and then we move up to talk about memory, so they have some understanding of those memory circuits. It's not just sort of being amorphous, but being physically instantiated. Of course, we need more research and more data. It's not a coincidence that, as you know, Tom Insel has gone from NIMH to Google. Why? Because as we harness more and more data, you and I and even all of us in this room aren't going to be able to process it. But Google and its allies can, right? So that's coming. More education. We've got to be humble about this as well. Brain science might not matter at all for law, and I think in many ways it won't, but I think in some ways it can. So here are the things that I focus on. So what's scientifically possible or impossible? Straightforward. How much I've been harping on this, and what actual kind of value added is there? Just because you've run a neat study of fMRI, of depression or bipolar disorder, does it help the client, or in our case, does it help the legal system do what it wants to do? I think, again, the answer right now for the most part is no, but maybe in the future that will change. I think it will. Is it actually feasible? The important question, is it ethical as well? So here I'll give you a spattering of things that we're sort of thinking about, some of which we're actually working on. I've mentioned brain death, pain, neurolegislation, this mental health, brain health connection, brain injury, concussions, wearable technologies, brain-machine interface, brain-body interface, cognitive enhancement, AI, neuromodulation, animal brains and rights. I haven't talked about that, but a variety of things going on. Just on treatment enhancement, this is kind of right up your alley. There's ongoing discussion right now about this line. What is treatment and what is enhancement? One of the reasons that I'm quite interested in electrical stimulation, in addition to pharmacological changes, is that it raises deep questions about this type of thing. So here's came from Alto Spillhouse, had our New Age cartoon in the 1950s and 60s, and most of the predictions are like wildly off base. But this one was not. By 2016, so I cannot wait for the new year, by 2016, man's intelligence and intellect will be able to be increased by drugs and by linking human brains directly to computers. And I see that the Apple Watch is on Kelvin's hand, so we're already part of there. And I bet many of you had coffee this morning, or even some sort of other form of drug. So is that enhancement? Is that treatment? The FDA cares about this. We care about this in law, and we care about it from a policy perspective. So one of the debates we have in the book and that we have with students, and that we'll be talking about on Friday at DC when I'm at a conference, is if someone comes to you and says, you know, and then you assess them and there's no way they have ADHD, whatever that is. Let's just set that aside. Let's imagine it's a stable category. They don't have it. But it's also clear that they're sort of at a B level. And they say, you know, using that mantra, my genuine self is a B plus student. So I'd like your help in becoming that genuine self, that B plus student. Is that enhancement or is that return to their norm? What if everyone else in their classroom is going to a certain type of school or going on to a certain type of career and they want to do that too? Or what if someone in the law firm or a first-year resident comes in to say, I want to be able to do all those things and these other things, and I think I need the stimulants to do that. How do you assess that? Turns out it's a really difficult question. We're trying to deal with some of these things, and it's even coming up to the high school level, right? So Minnesota high school students taking Adderall to boost academic performance. They're doing a lot of other things to boost academic performance as well, such as maybe getting better sleep, or eating differently, or studying hard. All those other things are brain modifications, brain manipulations. Goes back to what I was talking about before. So what makes this type of brain manipulation any different? Open question. Electrical stimulation, I mentioned that we're working on TDCS work as well. There's a large do-it-yourself community of TDCS. TDCS requires simply a battery, a couple of wet electrodes, a little bit of wiring, and you can go on Reddit or elsewhere. In fact, there's a whole set of websites where individuals will report, here's where I put this pad, here's where I put this pad, here is my voltage, and here are my effects. They're doing their own thing, right? Now, they're also doing their own thing in a lot of other ways. Here's what I ate. Here are all the things I ate today, and boy, I feel a lot better. Here's all the yoga I did this weekend. Hey, I feel a lot better. And what you know and I know is that although we cannot, with any precision, discuss the brain mechanisms that allow them to feel better, to overcome their fears, to overcome their addiction, whatever it might be, those behaviors that they're doing, those things that they are doing, either indirectly or directly to their brain, changes their lived experience. So does it matter that this particular thing they're doing looks different than yoga and feels different from yoga? And if so, why? And if not, why not? And would you consider using this? And in what ways is this different, better, worse than pharmacological interventions that you would assess? And for the legal perspective, then, we say, well, is it different than the way we treat drugs or not? So this political regulatory climate is sort of the interface that I work in a lot. I won't bother going into all the details, except to say that this is an op-ed we wrote in the Washington Post last year, one of their blogs. And the headline kind of says it all, neuroscience is coming to the law, can we keep the politics out of it? We're at a state right now, is evident, where it's unclear exactly what the value added of neuroscience is. There are hyped claims. There are also, I think, overly pessimistic claims. And trying to have an honest, forthright discussion in some ways involves trying to have that discussion outside the spotlight of politics. I mean, you can look at climate science this week as an example of the ways in which that politicalization has made it very difficult to have a reasoned policy discussion. Now, let me skip this and just mention two things at the end. So one is cultural change. The thing I mentioned at the beginning and opened with epilepsy, I think that's a big issue. I think it's a tremendously important issue for psychiatry. You know, these surveys come out frequently, and they ask this question, and the data often looks like this. They ask, if you had a mental illness, would you feel that others would sort of look down on you? And the responses are often 70, 80% say, yes, I would. If you flip the question and you say, if your friend or if someone else had this mental illness, would you look down on them? And self-reported, but the numbers are really low, like 15, 20% or less. Now, they might not be honest, but I think it is fair to say, and there's an ongoing discussion at the undergraduate level with Boynton about this continued stigma of mental health. And we see it. So if I break my femur today and I go wheel into class, everybody wants to sign my cast, right? It's a big deal, maybe even impressive that I did that. If I say, oh, where were you? Oh, I had to see my psychiatrist. Yes, I'm actually going to have to see him every week now. What is that reaction, right? And does that begin to change? Do we have a cultural change as we begin to see, well, I'm having, some sort of brain language associated with it? We're working on memory detection. I won't mention it. This is the last thing I want to mention because it's a very UMN-centered project, and it's, well, actually, the memory detection is too. It's with the Bill Iacono. We've got an NSF grant proposed. Maybe we'll get it. I'll have something to talk about. But this neuroimaging concussions, I think, is really illustrative of where I think the field of law and neuroscience is. So what could be more brain-centric than concussions? Right? I mean, we all know it's about the brains and CTE, and everyone gets that concussions are about the brain. All 50 states have now passed, including Minnesota, new protocols. Return to play protocols, assessment to come into the concussion protocol. And yet, not a single of those 50 states, nor even really the major football leagues, involves actual, for the most part, it's a little bit of an overstatement, but I'll make it anyway. For the most part, neuroimaging does not play a role in those assessments. It's appropriate. The National Academies has said, at present, we don't have the technology, the tools, the science, the research to suggest that adding brain data would actually improve our assessment of concussions. So if we're in a state where brain data is not even used in the, and what do we care about? Well, we care about behavior, right? So if you can do the working memory test, if you seem to look okay, if a week later you remember what day, all those things, that's what we use to assess. And we look at behavior, not brains. It reveals, I think, these truths. First, we do care about behavior, not brains. We care about brains only to the extent that it improves our understanding or our treatment of behavior, and it might in concussions in this way. Imagine that we have all experienced a concussion, we all come in for our assessment, and let's say, I don't forget exactly what the data would suggest, but 85% of us are going to experience no post-concussive syndromes. But maybe some of us would. And maybe our behavioral tests send all of us out here thinking, I'm fine. But if we all had some sort of imaging, and if, again, in the long run, that imaging could provide us with better understanding and early warning signs, it would seem to me that's a major progress. And that's what we do with heart imaging, right? Another University of Minnesota thing. You don't wait till you have the heart attack. You look for all the warning signs, genetic and otherwise. So what we're doing with CMRR is trying to build some momentum. We haven't launched any study yet. We're doing pilot study in this area. Where does that technological change come along? So you're not going to drag everyone to an MRI machine? No. So they've got Obama brain data to develop a portable MR machine. Maybe it's with EEG, maybe it's with additional technologies that folks are only starting to now examine. Well, I think, again, it's an example of the state of the field, and I'll simply end with this comment. Bill Gates has said that we often overestimate how much change there will be in 2 years, just about technological change, and often underestimate how much change there will be in 10. And I think that's an apt characterization, and maybe a somewhat apt characterization, you tell me, of biological psychiatry, a computational psychiatry. I can't imagine for all of my psychiatrist friends, would not be using any neuroimaging in their work tomorrow. But what about 10 years from now? What about 15 years from now? What about 20 years from now? And if we're going to get to that stage, what do we do now to make sure that we do it in a way that leads to a more fair and just system in law and in policy? So those are our challenging questions, and thanks for listening to me.
Do we have some questions for Francis here?
Francis, thank you so much for such a vibrant talk. I want to preface my question with some observations, right? You gave the example of the attorney who will get pulled up for ineffective assistance of counsel, and the case will be appealed if he did not hire an expert. Even if the conclusion is a no-brainer, you need a scientific expert to tell you there's nothing here. Secondly, we are in an adversarial system of law where if the prosecution hires an expert, then the defense has to hire one. The prosecution hires a second one, the defense hires a second one, and suddenly in big trials you'll see like 5 experts on each side. Thirdly, they are presenting scientific data to a jury, which is a bunch of common laypersons who don't have any scientific knowledge. Finally, if the case before finally, you said 95% of cases get settled. Because some of these cases become so big and so tedious, nobody wants to spend more time and money into this case. Finally, even if the case does get to trial, we have the Daubert Standard, where the judge is given the gatekeeper function to allow no matter whatever scientific testimony is to be introduced in court. Now, I make all these observations because junk science is not new to the courtroom. Right, and the term hired gun has been used forever and ever, right? So my question is, how many of these problems of introduction of junk science testimony and all this happening is because of complications in our legal system and not because of problems with the law?
It's a great question. I think that, just quickly, I don't think that there's anything particularly unique about neuroscience as it relates to some of the issues you just raised, which is battle of the experts in an adversarial system. How do you handle these things? And so in that respect, I don't think neuroscience poses a new problem. We've got framework for trying to address it. Those frameworks, frankly, have not worked very well in many cases, and they might not work very well in neuroscience. Where I do think, so in that respect, I think neuroscience is not new. Where I think neuroscience is new is in a variety of ways in which it does, unlike, say, some advancement in bite mark analysis. And bite mark analysis is horrible. It should really not be let in, but it sometimes is. Bite mark analysis sort of really a forensic-only type of thing. I mean, that's the only time you see it. Now, this stuff is showing up all over the place. And so I think there's this opportunity, either good or bad, for these systems to be working together. So if everything starts to be happening outside the courts, in neuroscience, but a bunch of things, I think that's going to affect the way that courts assess, and vice versa. If some technology is suddenly admitted and seen good there, maybe it begins to get used in other places. And I think that's distinct from, say, bite mark analysis, where you don't deal with bite mark analysis in your work. You do deal with assessment, and maybe someday, at least, and researchers, including many here at the U, are looking at biomarkers for those sorts of assessments. So there, I think there are some ways in which neuroscience bleeds in and out of the courtroom, but I'd agree that a lot of these issues are not new to neuroscience and are systematic on the law side.
Hi there. You told me that that book about Dr. Irvin. Dr. Irvin was my mentor while I was in psychiatry at UCLA. For about a year, I was the consultant to the neurology ward, and one of our patients came in. The moms and dads said that this young man would have violence. He would throw tables around. He didn't kill anybody. And at the same time, neurosurgery and neurology at that time were examining whether they could take out a little bit of the temporal lobe if that's where the focus of epilepsy that didn't respond to medicine was occurring. So they had a very interesting assessment, and that was to put the person in a neurology room. They had a TV camera looking at the person and the EEG on. Mom and dad brought him in. We evaluated him and everything. He was there, and maybe the second day he was there, you could start seeing his EEG get all revved up. Nurse was sitting in the room looking at him, and he pulled down the curtains around the bed, threw the pillow. She got out before that happened, threw the mattress off the bed, etc. And it was, so we reported in the neurology journal that in those people that have a temporal lobe epilepsy with a violent episode, that there was the connection from what we were able to see on TV and what we're able to see on the EEG. So it was the first report of that combination.
Neat. Thank you.
Another question?
Would you comment further on the National Football League's response to traumatic brain injury and what you might predict for the future in the geopolitical arena?
Of football? Of football? Oh, okay.
So the legal issue, the primary legal issue in my view in the NFL case, not just in my view, I think in the case, was the argument, you knew something and didn't tell us. Right? In fact, not only did you not tell us, you systematically attempted to push this information under, not unlike the link to smoking, cancer, and big tobacco. I think they were absolutely wrong to do that. I think they had a money interest to do it. And I think the settlement actually is, we know Judge Brody, and if you know the settlement, they proposed one settlement, Judge Brody said this isn't good enough. They came back with another, which I think still undersells the damage. But looking forward, I think it's a much harder legal climate to make that case, because I don't know that it's credible to say I had no idea that this might happen to my brain when it's all over the headlines, it's in the locker, I mean, this sort of stuff. So I think we're going to face one of two options. Steve Miles, you may know here, has recently argued that we ought to, and with colleagues, that we ought to eliminate football altogether. I am very much not in that view. I'm in the view that for a variety of reasons, we ought to have better information, but we ought to allow for market decisions. And that's going to be the same case, I think, frankly, in a lot of these other areas where we're learning more about the brain's potential risk and potential benefits, and we'll have to decide how paternalistic to get. We could turn it all to flag football and reduce concussions a lot, but we'd also reduce a lot of social benefit and indeed individual choices. So I think we ought to make it more safer, and I think we can, and I think that's probably where things are headed. But I don't think we'll see any of the big lawsuits like we did for football, though we'll see them still circle around. There's ongoing one for hockey right now. UMN law grad leading the, the plaintiff's charge. So great question. Thank you.
Thank you, Francis.
Okay,
Thank you
thanks,
for coming, and
yeah.
let's thank him one more time.